Next case on the docket is Big Lots versus Hyman.
May it please the Court. My name is Kelly Ruth. I'm with the Carlisle Appellate Law Firm, and I represent Big Lots. I'd like to reserve 5 minutes for rebuttal. This is an appeal of a final judgment and related orders in favor of the plaintiff, Ms. NELLIE HYMAN, following a 3-day non-jury trial on a trip and fall personal injury case. Big Lots appeals this final judgment that found it 100% liable for negligence. Reversal is required in this case for several reasons, and the 2 dispositive arguments I would like to focus on today both deal with the plaintiff's failure to meet her burden of proof. First, the plaintiff failed to meet her burden in proving that use of the QEEG in diagnosing brain injury is a scientific procedure that is generally accepted by the relevant scientific community. The first step in a
What is the QEEG?
The QEEG is a scientific test. It is called, is a computer analysis of brain waves that reflects what is seen in the EEG, which in this case it is normal.
Okay, now was the EEG subject to challenge under Fry?
No.
Okay, well isn't the QEEG just an extension of the EEG?
No, it is a separate test, and it is not generally accepted in the relevant scientific...
How is the QEEG, how is the Q part, the quantitative part, how does that relate to the EEG?
I don't know exactly how to define it for you medically. I believe that would be reflected...
No, describe it for me in lay terms or scientifically, or what does it do?
My understanding...
Let's get to the EEG. The EEG essentially measures brain waves, right, under the scalp.
Correct.
And how is it graphically depicted?
I don't know the medical
Well, it's
terminology.
graphically depicted on a polygraph, right? Peaks and valleys and things like that. And the QEEG part of it essentially takes the results of the EEG and digitally depicts them in the form of a colored picture in a round circle of the brain, right? Doesn't it?
I don't know, Your Honor. I believe you're going outside the record, and because it's a de novo review...
Well, don't we have to know what the science purportedly does in order to make a cogent ruling on whether or not it's appropriate for the trial court to consider that?
Correct, and in a de novo review, you can look at supplemental medical authority to do that, but in this case, neither of the parties have submitted that supplemental authority, so I believe at this stage at oral argument, it would be improper to go outside the record.
I know, but doesn't the appellant here have a threshold burden of adducing below from its experts some description of what this science is and what it does, so the court can understand what the science does?
No, I would say it's the plaintiff's burden to prove that the QEG is medically accepted. And in this case, the plaintiff presented no witnesses, no reports, no scientific reports, no documents were entered into evidence at the Fry hearing. The only evidence was brought by the defendant. Dr. Arausquin was Big Lots' expert witness at the Fry hearing.
Is it your position that Dr. Weiss's testimony, even if it's entirely believed, even when there's conflicts with other experts, is insufficient to meet the Fry standard?
Yes. First, I would say Dr. Weiss's testimony really shouldn't even be considered because he did not testify at the Fry hearing. But if the court would look at his testimony in its...
His deposition was taken by video.
Correct.
For use at trial. The motion for the requesting the Fry hearing wasn't filed until a few days before the trial, right? And everybody knew Dr. Weiss was going to be out of town, right?
Correct. So looking at Dr. Weiss's testimony, yes, he is one expert witness of the plaintiff. He's a biased expert. Under the law, that is insufficient. The Fry doesn't...
So he can't be used to establish the Fry, to meet the Fry test because he was hired by the plaintiff?
No, but he is one man, and Fry does not require unanimity in the scientific community, but it requires consensus by a clear majority.
I'm talking about, well, I mean, he testified about what others were doing, right? I mean, he said that other doctors were using this science, and the hospitals were using it, and I mean, he said there was an article that was written by scholars in the field of electroencephalography that said that this was appropriate for this particular purpose. I mean, he offered evidence about what others were doing, right?
Well, if you look at his testimony, he testifies that other doctors are using it, but that is not the issue on the table. That is not what Big Lots is challenging under Fry. Big Lots is challenging whether it is properly used in diagnosing brain injury. And if you really take apart Dr. Weiss's testimony, he's saying, yeah, these people use it, but he does not say...
Well, didn't he say that there was at least one article by 5 people that were experts in EEG that said quantitative electroencephalography is an appropriate science for diagnosing closed head brain injuries?
I believe it was appropriate for brain injuries, but again, there's nothing in the record. There's no report. I don't know what that report says because it was never entered into evidence.
Does it have to be? I mean, the doctor said that the trial judge believed him, right?
Yes, I believe it has to be. This court needs to be able to review scientific reports that support the plaintiff's position. And here, there's really nothing other than what Dr. Weiss says.
We have to read the report ourselves. It's not enough that the doctor read it and he told the trial judge what the report revealed.
Correct, and it probably goes to the weight, not the admissibility. But again, Dr. Weiss's testimony, the majority of it doesn't concern the use of QEG in diagnosing, and that is the trial court's error, is our position in this regard.
Let me move on to the harmless error issue for a minute before you run out of time. Wasn't Dr. Weiss's testimony was that this was just one of many tests that he considered along with his examination of the patient and reaching the conclusion that he reached?
That was his testimony, yes. And if you look at his own testimony, his diagnosis is flawed because he says in order to have a proper diagnosis with the QEEG, it must be correlated with other things. It must be correlated with an EEG. It has to be correlated with the clinical history of the patient and the patient exam. So if you look at what he did here...
Didn't he do that? Didn't he consider the MRI and the EEG and the patient's history and the patient's and a physical examination of the plaintiff?
He did not look at the plaintiff's history. He never looked at her Boston medical records. He did not know she was already reporting a 10 out of 10 pain. So he had nothing to compare what he was evaluating her now to what she was already suffering from before the fall. He did not correlate the QEG with the EEG because the EEG was normal. So under his own testimony, this was an improper diagnosis under Fry. It is clear that this is not harmless error because really the plaintiff's case comes down to this alleged brain injury. Everything else she's claiming was pre-existing.
She had a brain injury, right? I mean, you don't dispute that.
I do dispute that, Your Honor, and I believe, yes.
Don't your client's witnesses testify? She had a brain bleed as a result of the fall, right?
Correct, a brain bleed, and he concedes that's a brain injury, but that's like saying, yes, I scabbed my knee, that's a knee injury. That is very different from what is required to make a diagnosis for traumatic brain injury, and I believe you're referring to Dr. Lazito's testimony, and he goes on to make it clear that in order to diagnose a traumatic brain injury, and he cites to various organizations, including the World Health Organization, the American Academy of Neurology, American Psychiatric Society, the Defense Department, they all have certain factors they look at in order to come to the conclusion of a diagnosis of brain injury. These are things that are not present in this case at all. Loss of consciousness, concussion, dizziness, amnesia, focal neurological deficits. That's just a mild brain injury. He goes on to talk about a severe brain injury, which is what they're alleging in this case, and that requires a major skull fracture and major bleeding. None of that is present here. So look at his testimony in context.
So your position is that Dr. Weiss's testimony should have been excluded?
Yes, to
His opinion should have been excluded?
His opinion that the QEG...
Was there an objection to him giving his conclusion, his opinion about, was that question objected to? In other words, was the only challenge made by your client his reliance on the QEEG, or was there also a challenge made below to his opinion testimony?
At the time that he made the testimony at the video deposition?
Well, at the time that the trial judge considered the testimony, the evidence during the trial.
Yes, there were numerous objections. Well, first of all, the relevant objection would be at the Fry hearing when Big Lots counsel attempted to discuss QEG to diagnose the trial, and the plaintiff's attorney objected. The trial court sustained the objection and said that, I'm not concerned with that right now, basically. The Big Lots preserved the issue there, but clearly in the motion in limine, it objected to the diagnosis of brain injury as testimony. Prior to the trial actually beginning, there was extensive discussion between the parties and the trial court about this issue, and the court said it would take it under advisement. Before the video deposition was played, there was extensive discussion where Big Lots objected to this being played before the court. And then even after the trial was over, they discussed it again, and Big Lots said that we object to the diagnosis aspect of this testimony being admitted, and the trial court said it would take it under advisement and have a later Fry hearing.
Why don't you move on to your negligence argument?
Okay. Regarding negligence, the plaintiff also failed to meet her burden of proving negligence, duty, breach, causation, damages. There is not competent substantial evidence here to support those elements being met. First of all, as to the duty and the breach, I'll discuss those together because I think they're very related. There is no competent substantial evidence to support the conclusion that Big Lots failed to keep its premises in a reasonably safe condition because plaintiff had to prove there was a dangerous condition. Here, the shelving unit was at issue. It was not entered into evidence. There were no known measurements of the shelving unit. No one knows precisely how long this end cap extended. There's nothing conclusive here. No one knows how long Big Lots had it maintained in that position, how long, so that it should have known about the allegedly dangerous condition.
Wasn't the reason they didn't have exact measurements because your client agreed to preserve the evidence and then didn't?
Correct. And we were sanctioned below for that. That does not change the plaintiff's burden of proof.
Does that prevent you from making an argument about the exact that they didn't prove the exact dimensions if you all had control over the material and didn't preserve it?
No, I don't know any law that says the plaintiff's burden of proof changes under these circumstances. Really, all plaintiff's case comes down to proving a dangerous condition existed. It comes down to her expert, Dr. Rosen's testimony, and there even he admits he has never examined the shelving unit at issue. He's never seen the planogram. He's never seen an exemplar of the shelving unit. At the end of the day, his testimony is not competent substantial evidence. He relies...
We have photographs, don't we?
We do have photographs, yes.
And one photograph was taken immediately after the accident,
Correct.
and then there was another series of photographs that were taken within a short period of time.
Correct.
And it's agreed, is it not, that all of those photographs are of the exact end cap, right?
That is the plaintiff's position. I wouldn't say it's agreed. The plaintiff's position is that the store manager identified the shelving unit. But if you look at this testimony in its entirety, there's no reference. The record is not clear. She's even talking about these photographs that the plaintiff cites in her answer brief. And the photographs you're referring to, it's a composite exhibit of 4 pages with numerous shelving units. So to say that proves that was the shelving unit, I think is a stretch. It's not competent substantial evidence.
Well, but the photographs do indisputably show, do they not, that the shelving unit was not stacked in a manner that the plaintiff's expert would say was safe?
I think it is disputable. Looking at the photographs, I think they're at eye level. I think an argument can be made that it's stacked to the edge. It's just impossible to tell definitively from looking at the photographs. And again, there are multiple shelves in those pictures. Which one are we talking about? There are some that are stacked to the edge, clearly.
What do you refer to as the edge? Is it the side edges? Is it the top edge? Is it the front edge of the bottom piece? What do you mean?
The front edge equal to the end cap,
So the front end of the lowest piece of the end cap?
according to Dr. Rosen's testimony, I believe that's what he's talking
And it's your
about.
testimony that that was stacked with merchandise?
I'm sorry?
It was the record showed that that was stacked with merchandise?
It's not clear that it wasn't, is my point. Dr. Rosen says that would have been adequate warning, and it's our position that these pictures, they look like normal shelving units that you would find in any store in America.
Well, but the bottom protrudes, right? I mean, isn't that the problem here, that when you try to get around this end cap and you're looking straight ahead and you think that the end cap only extends so far, but what you don't realize is that at your feet the end cap extends much further, and isn't that the
Correct.
problem that causes the tripping?
Yes, and the issue is how far was it extending, and we don't know. There's no competent substantial evidence to
Well, I
show
mean,
it was inappropriate.
There's evidence that the plaintiff, you have to you have to argue your case within the confines of the most favorable evidence to the plaintiff. Are you saying that under the most favorable evidence to the plaintiff, there's not evidence that the bottom of this display unit protruded further than the display itself?
It did, but just because it protruded doesn't make it an inherently dangerous condition. And I would direct the court's attention to one of the cases I cite, Aventura Mall, where they look at an ordinary sidewalk curb, and they find that that cannot be deemed, as a matter of law, a dangerous condition.
Well, the plaintiff's theory, and the plaintiff's expert supported this theory, was that people are, when they see an end cap such as that, they orient to the end cap in terms of their height and where their vision is when they're looking at the merchandise, and they don't necessarily see something that's sticking out below the merchandise because they're not looking down when they're walking around. I mean, wasn't that their theory?
That was their theory.
I mean, and so your client obviously created that condition, so notice about it is not an issue. That your client created the condition. It isn't some spilled water or something like that. So if your client created the condition and this expert testified that that's a hazardous condition, and the lady says she tripped over it, or there was some evidence that she tripped over it, and doesn't that become a question of fact for the jury?
Correct, Your
For
Honor.
the trier of fact?
Just to point out briefly, the expert's testimony relied that it was a tripping hazard on the Florida Building Code, which, just a plain language reading, it does not apply. This shelving unit is not a walkway, a walking surface under the building code like a sidewalk would be. And again, back to that case.
But it really sounds like you're just re-arguing the evidence to us, Counselor. I mean, aren't these all arguments that were made to the trial judge? And didn't the trial judge believe the plaintiff's expert? Don't we have to assume that?
And the trial court certainly could have disbelieved this nonsense about the building code without disregarding the rest of the expert's testimony, which was when you have an end cap that's not appropriately stacked, you've got a dangerous condition.
What was the question, Your Honor?
The question is, I mean, your argument is that, well, this whole thing about the building code is just wrong. So we have to discount the expert's testimony. Well, the expert really, had two bases for his testimony. The trial court could have disregarded one and completely embraced the other one, which apparently he did.
Well, separate from the whole breach, there are other factors of negligence, causation, and damages, and our position is there's nothing to support that, including Dr. Weiss's own testimony about damages. He had an inadequate diagnosis under the QEG, And beyond that, there's really nothing there to support permanent injury, permanent damages. So that and causation, I know I'm low on time, but
You're down to less than a minute if you want to save anything for
rebuttal, okay, I'll go ahead and do that. Thank you, Your Honor.
May it please the court, counsel. Good morning, Your Honors. My name is Mike Lentini. I'm from the law firm Highstack, Gordon Kirby in Melbourne, and I represent the appellee in this case, Ms. Nellie HYMAN.
Is there a building code violation with this shelf?
According to Dr. Rosen, there was, Judge.
Well, according to you, is that credible testimony? Can this be a building code violation?
I believe so. The finder of fact, Judge Berger, he can disbelieve or believe whatever testimony he chose. I don't know if he believed that or not. Dr. Rosen testified that it was. I have no reason to doubt our own expert, but that was the testimony in the lower court.
Well, if we conclude that it couldn't have been a building code violation, should we then disregard the testimony of Dr. Weiss and reverse the judgment in your favor?
No, not at all.
Why is that?
Absolutely not.
I mean, if we find as a matter of law that Dr. Rosen had no idea what he was talking about on a legal issue, which is whether the building code applied here, then why shouldn't we just throw out his testimony and make you start all over?
Well, the judge had, I mean, the standard here is abuse of discretion. I believe we're speaking about the...
We're not talking about an abuse of discretion. I'm talking about a legal issue. Whether you can apply the standard building code to an end cap sitting in the middle of a retail store.
Well, I believe what Dr. Rosen said about the building code is that it applied to structures within stores, and they have to be maintained in a safe condition, and I believe that's what Dr. Rosen was, that's what his point was.
I understand what his point was. My question to you, since you are unwilling to say that that's nonsense, is if we conclude as a matter of law that that's nonsense, should we reverse the judgment in your favor? Should we throw out Dr. Rosen's testimony because he had no clue what he was talking about?
And your answer to this, the answer that Judge Griffin already gave earlier today, right? Did you hear what she said earlier today?
I did. Was the judge care to repeat?
Why don't you try there, you know, that the expert gave, you know, two alternative theories, and that the trial judge was free to accept part of the expert's testimony, the whole of it, or reject it all, and apparently, and the trial judge could have certainly accepted part and not accepted the other part.
Correct.
Right? Okay, good.
Do we know whether the trial judge accepted the building code part of the testimony?
I do not know that.
He didn't articulate the basis on which he found the negligence, right?
No, he didn't articulate the basis of it. He found it, which is in the verdict form, which is part of the record.
Explain your client's negligence theory separate from the building code violation. What was the negligence here?
Well, the negligence here was the fact that Big Lots allowed this shelf to exist in its store. I'm sure the pictures are in the record for the court to view. I actually was going to bring one this morning, and I searched my file. It turns out I forgot it. But the way the shelf was constructed, number one, it didn't meet what was designated in the planogram that Big Lots sends down to its stores and says, okay, these are how the shelving units are supposed to be constructed within the store. We have the planogram. The Judge Berger had the planogram. He looked at it. There's testimony about it.
That wouldn't create negligence, would it? Failure to make it consistent with the planogram wouldn't necessarily have anything to do with whether it was negligence or not.
No, but I think it helps. What I'm getting at as to how it was constructed. You have product, and this goes to what Dr. Rosen spoke about as well. We have this shelving unit. There's this long protruding base sticking out at the bottom. Then you have product that's not stacked out to the edge of this protruding base. So what essentially that does, creates some kind of illusion to the store patron who is, such as Nellie HYMAN, our client, walking from the register out around the shelving unit. What she sees is this shelving unit here with some product out only so far. So she is oriented that, okay, the shelving unit stops.
Did she come from one line and come out around the shelf and into the other line?
That was what she was trying to do.
And did she trip before she got to the second line?
Yes.
Okay, but she came out of the first line?
Yes. What this was, I guess I could demonstrate with this podium here that I'm at. Ms. Hyman was in line to buy some bleach. This is the cashier here. Ms. Hyman is standing over here to buy her bleach. There's a couple people in front of her. Another cashier over here says, "I'll take the next person in line." That was Ms. Hyman. She says, "Okay." She goes to walk around the shelf. The product ends here. She goes to take a step, and you got this protruding base sticking out that she can't see because she thinks the shelf stops here when in fact that's not. And that's what causes.
Did she walk around the other corner, though?
Which other corner?
From the first line. If she walked out of the first line and came around to go to the second line, did she go past the corner on the first line, so she arguably would know how far out it was?
Well, I think where she came from, she came straight into the line. She came past the unit.
The first line or the second line?
I believe it would be the first line, the line she was in.
All right.
So she came into the first line, walked past the unit, but, you know, you're looking at the thing head-on. You're not oriented as far as this protruding base sticking out at your feet. It's it almost is dangerous to the point, I don't want to get into argument here, but it kind of speaks for itself, the shelving unit. But that is the other grounds that Dr. Rosen was focusing on, that it was due to the configuration of the shelf.
If somebody was in line in the second line, they didn't come around from the first, all right? They're just in line for the second register. And as they came by, they ran into that end cap and tripped. Would that be negligence, or does it have to be because you've somehow come around the front end of it? It doesn't protrude into the cash register line, right? That's not the problem. The problem is it comes this way too far, correct? All
Yes.
right.
I think that'd be a bit of a...
Everybody in line there able to sue if they trip on it, or do you have to have come around and missed how far out it was from the front of it?
I think it's important that the way Ms. Hyman was walking, not that there's any fault on her part for walking that way. I don't want the court to mistake that I'm saying that should be any fault on her part. But when somebody walks out of the line, it's more dangerous than it would be if somebody is just walking, I don't know if it's the word, perpendicular to the protruding base, because then you're able to see it better.
Right. And did she testify that she tripped on that end cap, or did she testify she didn't know why?
She testified she did trip on it. And I know what the court's getting at. She is a very old woman, and the deposition took place and now I'm going outside the record a bit, but it took place up in Boston. She was shaky at first under direct when her depo was taken by the defense lawyer in recross. She did admit that she tripped on the base of the shelving unit. Additionally, there's also a witness, I believe it was her son-in-law, who testified he actually saw the whole thing happen and put an X on the shelving unit where her foot struck the base. I know that the appellant here mentioned the QEEG.
Before you go to the QEEG, let me just ask you about her position is that those photographs are incompetent. What's your response to that?
No, they're not. That's essentially my response. We had the manager for Big Lots testify that they were a fair and accurate depiction of how the shelving unit existed on the day of the fall, and it existed that way for as long as she's worked in the store.
I couldn't tell which one of the photographs was taken immediately afterward, and which, I mean, other than the fact that there was that lady who was standing in the others, but which one of the photographs is the one that was taken immediately afterward? Or the same day or something?
I believe they were all taken the same day. It was a composite exhibit.
Oh, I thought one was taken like shortly afterwards, and then another one was taken like a week afterwards. I'm wrong about that?
I believe so, Judge. I know they were presented to the manager on the stand, and she agreed that, yes, that's exactly how it was configured.
On the day of the accident.
absolutely.
Now, this was a pegboard arrangement, right, with hooks, with things hanging
Yes, sir.
on it? Your position would be, I guess, that the pegs would have to be as long as whatever the size of the base is for it not to be negligent? Is that the problem, that the base hangs out further than where the pegs come out?
The pegs are shelving or product.
Okay.
So yes, that's the problem here.
And it would have to be continually kept full, because if it got empty, you'd have the same problem?
Well, the way that it existed, there was a huge space there that you can see from the photographs. Now, of course, we didn't have an opportunity to look at the shelf because the Big Lots got rid of it. So what we had to rely on were photographs. And those photographs showed where the product was stacked to. Now, if they were stacked completely to the edge, will I say that this accident wouldn't have happened? Yes. I believe our client would have been oriented as far as where the shelf ended, or where it stopped, so she could walk around it. Obviously, if the product was stacked out farther, or if the hooks extended all the way to the end, and let me correct myself there. I wouldn't agree with you that just hooks. I believe there should be product on there. There's got to be something more than just a skinny hook extending out, I don't know, however far, 24
That
inches.
goes to the restocking issue, because if you
Yes.
set it all up that way and it was full, somebody came along and bought stuff, then you'd have a problem with it if they didn't get it restocked, right?
Right.
Because the hooks aren't enough.
I don't believe there would be. But again, the picture in this case speaks for itself as far as what wasn't there, how it wasn't stocked. I believe I have about 8 minutes left. I could speak about the QEEG for a couple minutes. I think it's important to point out, unless the court has any other questions for me on that other issue. The defense filed a motion in limine seeking specifically, and I'm just going to go ahead and read from the brief here. Big Lots motion in limine specifically challenged the use of the QEEG test to diagnose the existence of a traumatic brain injury. That was the relief that they wanted from the trial judge. And at the end of the hearing, that is the relief that they were granted. What we know is that the judge, who's also the finder of fact, didn't consider the QEEG evidence that...
He did not, is that what you said?
Correct.
You mean because of that comment that he made, that I'm not saying that your case lives or dies based on the QEEG?
Well, not exactly what...
He didn't exclude any reference to the QEEG, right?
No, he did not. But he just didn't consider it in the context of diagnosing a brain injury. What that goes to, the quote that Your Honor just mentioned, if I get into it, is the harmless error analysis of if there was error. I'm not saying that there was, but if there was any, it was harmless, and that just goes to show that the finder of fact here, which is the judge, didn't really consider the QEEG as a big part of our case, which it really wasn't. What we had here was how the QEEG was used.
Do you know what it is?
A quantitative...
No, do you know what it does?
I believe it's used to map out how the brain responds after...
Do you know how it's different from the EEG?
I can't be specific. I don't understand if I say something incorrect. I can tap dance and try to explain to the court that I think I might be incorrect if I were to do that. But what we have here is Ms. Hyman, what the judge relied on at this hearing is the defense expert showing up at the Fry hearing saying that it's useful and accepted by neurologists to use to determine brain function. And I also have interesting quotes from that expert that he stated that the QEEG is a useful tool for confirmation of a brain injury after an MRI or a CT scan indicates such. Also, he said it's accepted to establish functional impact of the brain injury.
This is the defense expert.
Correct, at this hearing. And that's what the judge accepted, that's how he accepted the evidence. So essentially what happened at that hearing was that Big Lots received the relief that they requested specifically in their motion in limine and this appeal followed settling that issue.
Saying that the judge ultimately received the QEEG information for a limited purpose.
Absolutely.
Okay. He understood what it purported to prove, and he accepted it only for that reason.
Correct.
Okay.
Correct. And what's interesting with the whole Dr. Weiss situation, he didn't really even use it specifically to diagnose. What he did use it for is exactly what the defense expert said about, and the court actually asked the defense doctor during this hearing, is it useful to confirm a brain injury after a CT scan or an MRI brain scan already shows brain injury, which is exactly what happened in our case. We have Ms. Hyman walk around, trip on the base of the shelf, knock her head. She goes to the hospital, and her CT scans, which show brain bleeds, the dual subdural hemorrhages, and there's also brain MRI as well. That in and of itself, according to defense experts, Dr. Weiss, who is our treating physician here, that's a brain injury. And that's what Ms. Hyman walked into Weiss's office. I don't know if she was walked in, she might have been with him, but she had a brain injury already. Dr. Weiss already knew that. And so he used the QEEG appropriately according to this defense expert. So I don't believe that there was any error on the part of the trial judge to admit the QEEG on just such a limited basis, essentially for what Big Lots requested, that it get kept out for diagnosis, and it was. Even if that was harmless, even if that was error, should I say, it was harmless. As we know, I believe the Fifth uses the but-for standard, taking out but-for evidence of the QEEG for the limited purpose that it was admitted to determine brain function. I believe that was the quote that Judge Berger used. Taking that out, a different result wouldn't have been reached here. And that goes to the judge saying, I'm not saying your case lives or dies based on the QEEG. That supports that. Here we have other evidence the judge relied on. We know he did. He mentioned out there other diagnostic tests that showed a brain injury, the CT scan showing the brain bleed, MRI as well. And also, Ms. Hyman had other injuries here from this fall. It wasn't just this brain injury. There's aggravation of her syrinx in her neck, shoulder pain, increase in shoulder pain, increase in hip pain, increase in back pain. It changed her entire life, pretty much. And that's essentially why this would be harmless error, if error at all. And that's my position. I believe I've covered everything that the court asked. I mean, there's a couple more issues. That's abuse of discretion standard. I'm going to go ahead and stand on the merits of my brief. I think it speaks for itself on that issue, but we're taking the position that the Judge Berger didn't abuse any discretion on issues 2 through 5, and there's absolutely no error under issue 1 as well. Thank you for your time.
I would like to address opposing counsel's concession that the trial court admitted the QEEG for a limited purpose. It's clear from Dr. Arausquin's testimony that this determination of brain function takes place after a diagnosis has already been made. And he's taking Dr. Weiss's testimony out of context. If I could read briefly, the trial attorney questioned Dr. Weiss on page 274 of the transcript. This is regarding the first consultation with the plaintiff. Quote, "I see that your impression was not yet that she had a brain injury." Answer, correct. It was only after that, when all the testing was done, that he did this diagnosis. The testimony was never that the QEEG was used for determination of brain function. And regarding the issue that the court should have considered and the error that the court made at the Frye hearing on considering the wrong issue, I'd like to discuss briefly Brim versus State. There, a DNA sizing ladder was an issue, and the court was not sure whether the defense was challenging the use of the sizing ladder in the Frye hearing, and essentially said, because the motion was very broad, it just challenged DNA testing generally, and it said if the defendant is challenging the use of the sizing ladder, the Frye question will be whether that sizing ladder is a scientific procedure generally accepted in the scientific community. So here we have a FI motion that specifically challenges the use of the QEEG in diagnosis. So my
Thank you,
point is,
Counsel.
that's the question
Your time's
that the
expired.
court should consider. Thank you.
Court will be in recess.